allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First up is our public hearing for Ordinance 2023-01, Water Supply Public Hearing, an ordinance of the Township of Frederick, Montgomery County, Pennsylvania, repealing and replacing Section 30, Water Supply of Chapter 240, Subdivision and Land Development of the Code of Ordinances of the Township of Upper Frederick as amended to provide additional protections for groundwater and surface water in the township. So, move on to discussion of proposed water supply ordinance change.
So I will just provide an overview of the proposed changes to the water supply ordinance. Section 240-30A, the language is amended to give more authority to the Board of Supervisors. So currently, the way our water supply ordinance is written, it defers primarily to the DRBC, Delaware River Basin Commission, for decisions relating to large-scale wells that are expected to drill more than 10,000 gallons per day. Okay, so this first section gives the Board of Supervisors and the township more authority over such applications. Section 240-30C, there's language added. This section has to do with hydrants, and this language is amended to require hydrants be sufficient in capacity as well as flow, as well as the number of hydrants in a new development. So it adds the language about capacity in there relative to fire protection. Okay. Section 240-30D1 expands the intent of the water resource impact study to focus on the potential impacts of proposed development on the water environment. Okay. Section 240-30.D2A requires that all projects withdrawing 10,000 gallons or greater of water to submit the water impact study to Upper Frederick Township for review and approval. So review and approval is added to this section. That was not there before. Section 240-30D3 requires water impact studies to consider the impact on all wells within 1/2 mile of the site boundary rather than the existing 1/4 mile, and it updates the scope of studies that must be considered as part of the water impact study. Some of the language in our current code was outdated. It referenced studies that might have been from the 1970s. So the language is strengthened to require review of more current studies. This section also allows the township engineer to recommend a Phase 2 study when potential water supply problems are identified as part of the Phase 1 study. So a development has to do a Phase 1 study no matter what. If it triggers certain thresholds, then it has to move on into a Phase 2 study. Currently, our language does not give the township a lot of control over that Phase 2 study. So what we've done is we've added some language to improve that control locally. When a pumping test is required, the test will be conducted with a pumping rate of 50% greater than the proposed peak rate rather than the current 20% greater. So we're increasing that rate from 20% greater than peak use to 50%. The proposal also includes allowing a geologist as a qualified individual to keep logs of the testing. Currently, it's just the driller that would keep those logs. Okay. Requires the monitoring of static water levels for 24 hours prior to pumping, and requires the pumping test to be conducted for 72 hours rather than the current 24 hours. So again, making it a longer test. Finally, this section requires contacting of owners of wells within a 1/2 mile of the site, and the developer has to offer to monitor those wells during the testing. Okay, so that's part of the Phase 2 requirements. The proposed updates also include the creation of Section 240-30E, which establishes a bonding requirement for the developer. So this is language that requires, when a development is being developed, for every new dwelling unit that is proposed, the developer has to set aside $500 into sort of a pot, so that over time, if the neighbor's wells are impacted, the money from that pot of money would be used to replace those wells on neighboring property owners within a half mile. Currently, that standard is a quarter mile, and so it's being increased to a half mile. And let me see here. And then that funding has to be maintained for 7 years after the development is 90% complete. All right. The draft that was advertised includes language that requires the neighbors to contribute $200 towards replacement of their well. This did go to the Planning Commission, and the Planning Commission made a few recommendations, which I think our solicitor thinks are minor changes. And those changes include the elimination of the requirement that the neighbors have to pay $200 towards replacement. And they also, the PC also recommends that the $500 contribution required by the developer could be changed as part of the fee schedule. So down the road, if it's determined $500 isn't the right amount, the supervisors could increase that. And then also the final recommendation from the Planning Commission for minor changes, rather than having the developer provide just a bond, they are suggesting language that would allow other types of financial securities, such as a letter of credit, which is easier to work with. And that is a summary of the proposed ordinance changes.
Mr. Frisco, if you like, I'm not sure what we have planned next, but I should run through the legalities, all of the legal requirements to amend the subdivision and land development ordinance. And in order for the township to do this, like the scheduling of this public hearing, I'd be happy to run through those things if you like.
Please.
Okay, thank you. So as Tracy said, the township already has a subdivision and land development ordinance that already has protections for well water. But the township and the Township Planning Commission, as they often do, reviewed those provisions and thought that some amendments or some enhancements to better protect the groundwater and well water in the township were appropriate. So the Planning Commission, over a couple of months, worked on amendments to the existing ordinance subtitled Water Supply, and has recommended to the township supervisors that they enact those amendments. But to do so, the state law and the township code have various provisions for steps that have to be taken before the township can just enact changes to this subdivision land development ordinance. And although I brought them, I'm not going to read through all the requirements. What I will instead do is tell you what the township has done in compliance with the rules in order to make such amendments. So first of all, the amendment, this repealing and replacing the existing ordinance, was essentially generated by your township's own planning commission. A copy of the draft ordinance was then sent to the Montgomery County Planning Commission, who has 30 days to comment on the proposed changes. And they did that by letter dated March 30th, 2023. And the significant recommendation they made was that there should be a requirement for any developer to establish a bond in the event that their water drawdown adversely affects someone's existing well. And so the matter went back to the Planning Commission a month later, and the Planning Commission decided that that bonding language should be added. The township then passed a resolution to schedule this public hearing. In order to schedule a public hearing, notice, first of all, a legal notice had to be prepared, and then published in a newspaper of general circulation, in this case was the Pottstown Mercury, on April 19th and April 26th, in accordance with law. A full copy of the ordinance, because the ordinance is 8 full pages, the whole thing is not published in the paper, but a summary instead is published. And when that's done, there's a requirement that a copy of the entire ordinance go to the Pottstown Mercury, and that was done. There's also a requirement that a copy go to the Montgomery County Law Library, and that was done on April 17th. Copies of the ordinance have to be either posted or made available at the township building, and they have been so available. At a subsequent township meeting, and then just a review of the draft ordinance, I went through and I found a number of minor things that I thought should be changed, or just a couple phrases, a little punctuation, making sure numbers were correct. And those were a few minor changes that had been made to the ordinance. And then the matter went back to the Planning Commission on April 27th, and they suggested 2 additional changes that Tracy just summarized. The reason I say they're minor changes is because if there is a substantive change to the ordinance after it's published and after the county looks at it, you essentially start the process over. You have to go back and re-advertise, maybe have a second public hearing, etc. But it's my opinion, and I'm comfortable in saying this, that the changes were in fact minor, and I think we could just move forward with the ordinance as it's now drafted. So that is a recap of the requirements and the things that the township has done. I have proof of publication and copies of things that were mailed, the letter from the county, etc., are all in a file here. The only other thing the ordinance and the rules require is this public hearing, and there will be at some point an opportunity for comments, questions about the ordinance, or comments in support of or in opposition to the proposed ordinance. And then this hearing, when that's done, will be wrapped up. This meeting will be completed, the public hearing will be over, and as you should all know, there's a meeting scheduled at 7 p.m. this evening in the same place, where this ordinance will be on the agenda for enactment, and that has also been advertised, that the supervisors will consider adopting this ordinance at 7 p.m. But that presupposes that there are not any significant changes to it based on anything the supervisors wish to change or anything that comes about as a result of this public hearing.
All right.
If I can just add, I know many of you have been to the Planning Commission meetings and that sort of thing and been part of this whole process. A couple meetings ago, I believe, there were some questions about this water supply and drilling and kind of some of the procedural things and more technical questions. So we do have Rick Sachs here, who's our environmental engineer. So if folks do have some of those more technical questions, he's available and can answer those tonight, hopefully.
Okay. All right. So are we opening this up to comments and questions now, or are we
Yes.
talking about this, or?
It's up to you guys. You want to talk?
Well, let's talk about the comments. Okay. All right. Comments and questions. Who wants to step up?
Ladies and gentlemen, Dennis Hatcher, pleasure meeting y'all. First time in a meeting like this, so bear with me. I'm nervous a little bit. But let me pose a question to the Board of Supervisors. If I go to a doctor, right, and all of a sudden he says, well, have this mechanic look at you. It's kind of the same, right? A doctor is just a glorified mechanic to some extent. No offense to any doctors out there. But, is that right? I wouldn't think so. So, why would a local supervising board take away the authority, the expertise from another organization. You said it was the Delaware River Authority, is that correct?
Yeah, Basin Commission.
Basin
So just to be clear, it doesn't take it away from that, it just
Gives y'all more authority, right? To where I'm sorry to cut you off,
Yes, go ahead.
but to give more authority to y'all to maybe override some of their expertise and knowledge. What else would it be giving you more control? What would that entail?
So it could be more stringent requirements
Okay.
locally.
And then, so I just want to pose that question about the contrast, why would y'all want to pull that from them? So if it's to help us out, that's great for the citizens, okay? The other aspect is, $500, okay, that's a lot of money, but it's not enough to replace a well. So if we have a study, we go in and say that before we build this place, division, whatever, maybe any development, and we do a study, how is that going to determine, even if you got proposed usage, how scientific is that proposed usage? What if they're going to have more people living in this new housing or whatever may be built, apartments, duplexes, whatever the case may be? How's that any different than me going to the store, saying, I want a 2-liter soda, there's 2 liters there. But I want to take that soda to a party, I don't know how many people's going to be drinking out of that. I think there's going to be 10 people there, what if 20 people show up? How is that going to be accurate? How is that going to safeguard the residents? Where we got real concerns, not only of the well running dry, but what if it starts getting polluted? What about the cleanliness of the water? Is that covered in any of the ordinances?
I guess first, as Tracy stated, the Delaware River Basin Commission, they have primacy in setting the legal requirements for these types of things, and they have to provide a permit for the groundwater withdrawal. So the developer can't pull any water out of the ground unless they have that permit. And as mentioned, this area, all of Montgomery County is in the groundwater protection area. So any daily pumping greater than 10,000 gallons per day requires this permit from the Delaware River Basin Commission. And they establish certain criteria, and they will also monitor what type of testing is done by the developer. They'll review the data. They're very tough on that. And this ordinance isn't to take away their authority. It's to add to it, because where they have requirements, this provides an extra safeguard and buffer for the township residents to protect the people from somebody coming in and basically pumping more than they should. And any development, they're not supposed to be pumping more than the recharge that's going in on that same property. And the Delaware River Basin Commission does specify requirements that if it's any expanded withdrawal of the groundwater in the protected area, if you have a problem created to a neighbor, there are mitigation measures that they require. Could be providing alternative water supply of an adequate quantity and quality, providing financial compensation to the affected well owner, and such other measures as the commission shall determine to be just and equitable. So it's not just that $500 there to protect you. There are other requirements.
Thank you. So a couple of questions from that. Thank you for the explanation. I love being informed. So the testing would be done pre-construction, right? And there's proposed limits of 10,000 gallons. Who's going to be monitoring that?
Well, as part of their test, they have to do first they have to put their wells in. They have to determine, can each of those wells provide what they need? To have a public water system, you can't just have one well. There has to be a redundancy. So you have to have at least 2 wells, just in case one well pump goes bad or something, you've got capabilities. It might take more than 2 wells to get what they need, but the initial steps just to put some wells in, look at what kind of yield can they get. They might find they may not be able to get the yield that they need out of 3 wells. They might have to have more. But that's the first step. And then the second step is where they do the pumping test to look at, okay, how far out does their drawdown extend? Does it extend over to your house or somebody else's house? And that's part of the requirements that the DRBC has, and also part of what the ordinance protects as far as having residents have the opportunity during that test to have their well monitored. Have a pressure transducer put in your well so that when they're pumping, they can show they're not creating any drawdown on your well or any other.
On an ongoing basis, or just during a certain
During,
time frame, or
during the aquifer test, just during, they have to do.
So they could put, sorry, but they could put the wells in, do all these tests and stuff, and then have people start moving in. Or
No,
after.
it's permanent, they're permanent for a set withdrawal, period.
Okay.
They
okay.
cannot increase
They
that.
cap it.
If,
They cap it
yes,
something.
DRBC tells them, this is what you're permanent for. They can't just go and increase that. If they're pumping greater than that amount, then they get fined, or they end up in.
And who monitors that?
The DRBC does. And-
But if there's going to be ways to enhance it
Mhm.
with the board of supervisors, what's the process of overriding what they may come up with? Is there a process where that happen?
The township supervisors wouldn't want to override, and they can't legally override what the DRBC says.
Then what's
The
the
DRBC
enhancement?
sets the
Sorry, what's the
minimum
enhancement?
requirement, but the supervisors would have added capabilities, because they're the ones closest here. They're the ones most in touch with everybody and with the township, as opposed to somebody sitting in Trenton that works for the Delaware River Basin Commission. So these guys are going to have everybody's interests here, firsthand. So they're going to look at all of those details and use the extra capabilities of this ordinance to enhance what DRBC does.
So then back to the question about the board of supervisors having more authority to refine things. Can you give me some examples of what y'all might use that authority for?
Well, I think as far as refining, so this code essentially is just, for the most part, saying that when you do that testing, you have to monitor a wider range of wells than what we currently say. We currently say a quarter mile and up to a half.
I'm not
As
100
far, what's that?
So if there's, the proposed development by my land is like 100 feet, so, and I'm on a hill. And that's another question I'd like to follow up, but please
Yeah.
continue.
So I think the big thing is the length, as far as like what they can sort of have flexibility over, it's that $500, right? So they can increase it, to your point, if when a development comes in and, we kind of look and see how many homes it's gonna be and the potential, they could say $500 is clearly not gonna be enough. And what they'll do is they'll turn to their professionals, who this is what they specialize in, and they'll give the supervisors a recommendation. So they're not just like throwing a dart, at a board. They're gonna consult and ask.
Yeah, well, they're just,
Yeah.
and also the Delaware River Basin Commission looks for public comment and input. So they're going to take into consideration something that the township has a concern about.
Okay. All right, thank you for addressing my questions. I will save some time for other folks that want to speak. Thank you.
Thank you.
I think for saying override, but ultimately we're adding on top of what this already, this.
You can repeal and
Yeah.
replace.
We're not like replacing, we're not giving, like, it's not a, do
You mean in relation to the DRBC's requirement? Right, this enhances what the DRBC already requires and provides a little more local input and evaluation of that information.
Okay.
So, sorry, quick follow-up. So the wording again, and what the proposed changes are to the ordinances, does it specify that it enhances, or does it specify what the authority hand over to the board of supervisors?
I'd like to follow up with that in section A. We just talked about the township supervisors not enhancing, if we could go over that, please. That's a great point.